Well, the case was about, it described about, if I remember correctly, it was that they, and if I can quote, the case stated that in a country that is governed by common law, and according to that law, in order to maintain proceedings successful.
What are the facts of that case?
If I can reserve that and refresh later on the case, because I don't quite.
Please have the intention of refreshing us. We're going to call late. So maybe your call counsel can work on it.
Yes, yeah, if you can work on it, and I will get to it. If I mean.
So just to check, one of the things that's been said as regards Locust and as regards this contract, who are you expecting, this is a question on the other side,
Yes.
it said, who are you expecting the income tax to come from?
Well, the income tax, basically, the subsidiary operating in my client's country, we still expect to get taxes from him. From the subsidiary, because it is the law, and we have laws in our country that govern to that matter's effect. But when it comes to the issue of privity of contract, we do not have, he's not part of our contract, so he cannot claim to have a stand to come and initiate a suit in this court, in this honorable court.
So this court can only entertain contractual claims?
Yes, can you?
This court can only entertain contractual claims?
Yes, well, to that.
Is that what you're saying? This court can only entertain contractual claims?
Well,
Claim under George or claim under
I don't think if the court can be curtailed to that much, but based on the facts of the case and the contract we had, I think it's best if the courts rely to the aspect of privity of contract, and to that effect, rely on the paragraph 20 that I just stipulated.
Okay, and can you explain to me, just in the same context, why this subsidiary was given a certificate of compliance?
Well, the subsidiary company, Lejonzi Limited, operating in Gatwick, was given a certificate of compliance because it was a foreign company. That was, and by virtue of the Companies Act and as stipulated by the Council of the Plaintiffs, pursuant to Section 487, since it's a foreign company and most of its shares are owned by the first plaintiff, who in fact have who we have a contract with, they can only be a subsidiary in our country.
Who can only be a subsidiary in our country?
The Jonesy get the subsidiary company opening that was opened in Gatwick.
Where is that second company incorporated? Are you aware?
In the Isle of Ndanzi.
So the G Limited?
The G Limited is in Gatwick, but the first plaintiff, who is known as the Jonesy Mining Company, as read in the facts and in the contract, operates in the Isle of Ndanzi.
So why does that company have a certificate of compliance from your government if they are incorporated in our country?
Well, because that's what the law dictates.
Does it? You don't know the answer, you don't have to say it.
Based on the Companies Act, and with knowledge of, to that effect, with that knowledge, a foreign company, when a foreign company wants to establish a business within within our client's country, he must have a certificate of compliance to actually operate in our country.
I would invite the council to refresh his corporate law branches
Yeah.
and subsidiaries, and we can discuss that later.
Yeah.
Please carry on.
Yes, so to that effect, I'll pray to this honorable court that they strike out the suit, since the second plaintiff does not have locus standi to initiate locus standi and order payment of the costs by the plaintiff in favor of the defendant. And moving on to the main issues, I will direct the attention of the court, as it was already stipulated by the lead counsel for the defendants, that I'll be working on the permanent sovereignty of the natural resources and the public trust and parens patriae aspect specifically. And moving on to that, the president can invoke the doctrines of public trust and parens patriae to stagnate the ongoing mining activities, as to the effect that the public trust doctrine, as already stipulated by the Council of the Plaintiffs, that this doctrine embraces that resources that are found within a country are vested or under the control of the government, that they should look out and make sure that the state or the citizens of that specific state being Gatronia, the citizens should benefit out of that. And moving on to the parens patriae, which enforces or dictates that the government should be the watchdog over those resources for the interest of the state.
Sorry, stop you for a second. On the public trust,
Yes.
did you give us the authority for the doctrine of public trust?
Well, we didn't. I researched on it, and if you look into our written submissions, we don't have a case, but I remember a case that we read, although I can just tell you about the case. It's Illinois Central Railroad versus Illinois.
But counsel, you are invoking, you have enacted, I'm trying to get clarity here.
Yes.
You have enacted a law that, and I refer, you have enacted laws, Natural Wealth and Resources Act, as well as the Unconscionable Terms Act.
Yes.
In this law, they state that when it comes to matters of natural resources,
Yes.
no foreign applicable law shall be applied, and these laws are already in place currently in Gatronia. So how persuasive is your case from Illinois to this court?
Can you please?
What I'm trying to establish
Yes.
is that do you have any local authority to submit that the doctrine of public trust works in your favor, as opposed to now you citing a case from a foreign jurisdiction, given that you've passed a legislation that bars not only foreign courts but also foreign legislation?
Well, to that effect we have, and we have just tried to embrace them within our written submissions. As you can see, we tried stipulating Article 9 and Article 33 of the Constitution of Gatronia, which in one way or the other, let's take an example of Article 33(2) of the Constitution of Gatronia, which states that the president, who is the head of the government, has to act in fiduciary duty for the interest of the citizens and protect them from exploitation of their resources by the investor who left majority of the Gatronians in deep abyss, as it is witnessed from the fact itself and the investment agreement itself.
It actually says in the Constitution that he has to protect the Australians from the investor. What does it actually just say in the Constitution?
Well, Article 33(2).
Yes.
Article 33(2), if I can paraphrase it, it holds, the president shall be the head of the state, head of the government, commander-in-chief of the armed forces, and in line with this provision, yes, full stop, yeah.
And you've now inferred this provision
Yes.
to mean that the president has this fiduciary duty.
Yes, him being, by virtue of him being the head of the state, he's supposed to act in fiduciary of the best interests of citizens.
Now, if the company in Tanzania,
Yes.
is it not as a citizen of the country? Is it not a domicile in this country?
Well, it is,
A country that has had a lot of economic problems for many years. We've been in major recession. Does it not also have to the head of state a duty of companies in the country
yes.
that actually raise communities, education,
Yeah.
and the ability to grow as a country?
Well, I'll direct the mind of the court if I was to answer you. Well, looking at the facts, I will try to direct the minds of the minds of the court towards Article 18 of the facts, and also looking at back to the investment agreement. I'll direct the mind of the court towards towards Article 5 of the Lilo Mining Pact, based on the incentives. Now, what I'm trying to state or tell the court, this honorable court, is that the government was willing, in fact, to provide incentives as it's seen under Article 5 of the investment agreement. And though in one way or the other, we may see that the government has tried its level best, even you may see that there are some terms within this contract that are very detrimental to the state. I'll give an example, as even seen under paragraph 18 of the facts, that let's take an example of the corporate income taxes, which are supposed to be paid years of operation from 1980. and a whole lot of them that are seen that I don't have to mention. Now, if really this company, I purely agree that it is a part of the state and based even on international standards of most favored nation principle, our government was subjected to treat them correctly, but President Revendov was, as the head of the administration of that government, was left without any option rather than to retaliate from the actions that were done by the company. It refused to pay taxes, regardless of the incentives that the government gave. They still evaded taxes. They didn't give the state its free carried interest share, and to that effect. They refused to pay taxes on what basis? They refused to pay tax. They refused to pay taxes, or if I may refresh, they refused giving the state its share of the free carried interest as described under paragraph 18 of the facts.
Sorry, it says that the company claims to be incurring yearly losses.
Yes? Paragraph 18.
Yeah.
Paragraph 8. Yeah, it's declared that it's earning yearly losses because, in fact, in the beginning, it had the parent company, which operates in the Isle of Ndanzi, is a notorious tax haven, as even described in the facts. And what the subsidiary company were doing, they usually declare losses for a run of 20 years, but the parent company in the Isle of Ndanzi is just declaring profits, while
How does the parent company make a profit if the subsidiary company is not paying dividends?
well, based on the knowledge of tax law, I think they were trying to evade tax by transferring all the capital that was gained here and transferring it to the notorious tax haven so that they may get benefit.
Transferring cash. We're in the wrong court, aren't we? Council? Should this not be a criminal matter if they were just sending out cash?
That was their move, and how if you may try to the knowledge, if you may, from the paragraph 18, if you try to illuminate what they were trying to do, they were trying to evade paying tax, because it's clearly stipulated that even it is stated when the Bank of the Universe gave out the investment publication, it said that the company declared a $5 trillion profit while it was not paying corporate income taxes and still was declaring yearly losses.
The other company claims the profits.
Yes. Yeah, so moving, if
Council,
yes, yes,
a few minutes ago,
yes,
our leading judge asked him to your colleague,
yes.
what is the recourse when someone is not paying tax, or when someone is alleged to have violated certain tax obligations? What is the recourse? Do you confiscate assets of just any company just because they're not paying tax?
Well, we didn't.
Under the tax knowledge that you have, under the tax administration law that you decided.
Well, under the recourse is as it was done, the Gatronier Revenue Authority, through its Commissioner General, as the head of the authority itself, issued a jeopardy assessment, since the client of the plaintiffs refused to file a yearly assessment, which is a requirement of the law in the Income Tax Act, to that effect. And by virtue of that, it is clearly that, trying to getting to respond to your question, the president was, in fact, did not take any of their properties, but he issued them a letter from, as if I can direct the mind of the courts towards.
So you said the president did not take any of their property. The 300 acres that the president has acquired.
As
Who held that land? Who held the 300 acres?
well, if you may view it in that position, as it was already described by my co-counsel, by the lead counsel for the defendants, is that the President Revendov, was the third democratically elected president to that effect, and to our stance as the counsel of the defendants, he was more of a democratic president compared to his predecessor, President Doba Hunan, who in fact was the one who he illegally acquired the land and gave it to the plaintiff's client. Basing on the fact that the president has fiduciary interest, if the President Reverend Dove come in and acquiring that land back, and by virtue of that, human rights will always prevail to that circumstance, taking the land back to the people was justified to that effect, if I may bring the matter of court to that. So, if I may move on, if it pleases you. No, I'm moving on. I'll just
one point with what you said.
Yes.
So is it necessary then that the parent company,
Yes.
if they're making profit,
Yes.
that means that profit is coming from the subsidiary?
Well, but if I may respond to that, if I'll please respond to that, my ladyship, is that, yeah, in fact, it is true, because moving on to the facts, if you look at the facts, you will see that the company was making a... Can you please rephrase that for me? Excuse me. Can you please rephrase that for me?
One of the things you've said
Yes.
is that although what you're saying is
Yes.
a petroleum company,
Yes.
that's saying they're not making profits, they must be lying because its parent company has made profits. Do you know the source of those profits?
Based on the facts, their only involvement was only mining gatronites. So I don't see there any other source of income.
So the only mining company has no other source of income?
It has no other source of income, so their income must come from our client state. So it means they only mine gatronites, and it's even stated in the facts.
They don't mine at all. So just to clarify the point,
Yes.
yeah, there are two companies. There's only mining company as parent company,
Yes.
and there's only, we'll call it G Limited, the subsidiary.
Yeah, in Gatronia.
Whose job is only mining?
The one in the subsidiary, in Gatronia.
So I'm asking you, is it necessary that the parent company, if it's making profits, that money comes from the subsidiary? Could it not have other subsidiaries? Are there no other, have you looked into this point?
Well, but looking onto the facts, it was never stated if they had indulged in any other business. So we as the Council of Defenders pretty confine ourselves to the fact that they made profits from our state.
So it says in the fact that the profits have been directly made from the subsidiary.
From the if I may try and direct the mind of the court towards that.
Which line?
Well, the same paragraph 18, and in the last lines of the paragraph, the subsidiary in Gatronia had been declaring profits over a 30 years period, with its sole source of income being Gatronite mining and exports from Gatronia. So if I may move on to something else. So I'll move on to in fact, the last argument based on public trust doctrine, and the permanent sovereignty over natural resources. Well, with regards to the doctrine of permanent sovereignty over natural resources could be invoked by Gatronia, I'll confine with and direct the mind of the court towards this principle, which entails that the right of a sovereign state over its natural resources exclusively belongs to its people or inhabitants of that specified area. Despite the plaintiffs having this contract having a stabilization clause, this still did not, in one way or the other, stop the president from invoking this doctrine, since it is seen clearly from the facts, from the paragraph 18 I mentioned, from the incentives I gave. They made sure that this agreement was, in one way or the other, impracticable for the state, because they made it very hard. So the only option that the president was left as a means of retaliating from the bad actions of the plaintiffs was to invoke this doctrine, which actually, in one way or the other, supersedes the contractual obligations they had. And if I may also state that sovereignty of a state is extra-contractual to that fact. And if this court may be persuaded by the decision of the tribunal in the case of the state of Kuwait versus the American Independent Oil Company, and if I may ask the court to quote what they are described in their decision. With the facts of this case, the state of Kuwait had in the American Independent Oil, which was the company that operated in the state of Kuwait, had expropriated their investments, their oil running business in the state of Kuwait, and to that effect, the arbitral tribunal held that a contractual clause cannot claim an overriding effect of a state sovereignty because the government of Kuwait saw that to that effect it was this court that may pray that it declares that the permanent sovereignty of natural resources could be invoked by Gatronia. And if I may wind up with the conclusion and prayers.
I just ask, though in these circumstances and relying on these acts
Yes.
that you're talking about, if Gatronia continues to do this, will it be able to attract investment?
Will Gatronia be able to attract investments?
Yes.
What actions exactly were they?
Tear up a contract. If you say that you can change law anytime, there's permanent sovereignty over natural resources.
Well, I don't think if the acts that were done if we look at it in one way, you may say that they may not get investors in the coming years, but if you confine yourselves to the agreement that we entered with the state entered with the plaintiffs, and the series of events that the plaintiffs themselves did to the investor, I think it's clearly that there was a need to change this. And if we were to, our clients were to have another investment agreement with another state, with quite being open and a viable agreement, I think it will still work for both sides. So if I may direct the mind of the court towards the conclusions and prayers.
Counsel, I want to bring back to the case of Induna Shubi Balozi versus the registered trustees of Chama cha Mapinduzi.
If I,
Co-counsel may assist you.
yes, if I may welcome my co-counsel to assist.
And I specifically ask you to briefly tell us the facts of the case.
Yes.
And distinguish this case because both you, the defendants, and the plaintiffs have used the same case
Yes.
to argue for and against local standard. Therefore, I want you to briefly highlight the facts of this case and distinguish it from the point that was made by the plaintiffs in order to support your case as why the second plaintiff should not have local standard.
If it may please you, my ladyship and my lord, my ladyships and my lord, if I may welcome the lead counsel for the defendants to help me with that.
Amen.
Yes.
Do you want to approach the podium?
Your Lordship and Your Ladyship, in this case, the Rujuna Shubi was a plaintiff and the registered trustee of Chama cha Mapinduzi was the defendant, whereby he sued the registered trustees of Chama cha Mapinduzi, and he sued on the basis that on the public trust, no, on the public litigation that he was representing the other persons. And where this case came up to the court was trying to show how that the local stand operates. And the court has said that the local stand is a common law principle that any person standing must prove to have the rights or interest and how such rights or interests have been deprived or there is a threat to deprive. In this case, the court has explained on two means of getting interest. That is, it may be from the private part relationship or from the public litigation, and considering that during the decision of this court, there was no act that has affected the public litigation, and the court taken press to explain on how a person may use a public litigation to have an interest, and also explained on the private arrangements. That is, if there is any relationship subsisting between the two parties, and such relationship impose the rights or interest, then this person may claim to have the interest in the case, and therefore making the locus stand.
So to conclude, you have distinguished that case, and you're stating that this case cannot apply in favor of the plaintiffs?
Much obliged. If I'm not mistaken, what the plaintiff trying to say was to show that the requirement that was provided by the case of Rujuna Shubi, and it is my trite view that he was trying to explain on the issue of interest and rights as one of the factors which may make someone to come up to the court so as to seek for the cause. Much obliged. Please, if it may please this honorable court to answer the question that I was received on the issues of procedures of enforcement of fixed decision. If it may please this honorable court.
I think in the interest of time, because the bench definitely wants to go for lunch, that we do not answer that right now, but we can discuss it.
Okay.
Later.
Much obliged.
So if I could ask your co-counsel to please make his conclusions and make his approach.
Yes. So if
I'm giving you 4 minutes.
Thank you, my ladyships and my lord, for this opportunity once again. So I'm going to make the conclusions and prayers for our clients, the defendants, that first, the matter is not admissible before this court, and alternatively, the court is ousted of its jurisdiction to hear and determine the matter. And secondly, the second plaintiff does not have locus standi to initiate this suit. And thirdly, the acts of the Honorable President of Gatronia have amounted to the breach of the Little Mining Pact. The President can invoke the doctrines of public trust and parens patriae to stagnate the ongoing mining activities. The fifth is the newly enacted laws are applicable to the Little Mining Pact, considering the existence of the Stabilization Clause under Article 8 of the Pact, and the doctrine of permanent sovereignty over natural resources can be invoked by Gatronia, and that this suit be struck out and the costs be borne by the plaintiffs and any other equitable remedies this honorable court deems fit.
Thank you. One last question, slightly naughty.
Yes.
Why are you defending this case and applying for it to be struck out and not staying it
Yes?
for arbitration?
Can you please?
I understand that you agree to the exit arbitration rate, and you agree to the defendants agree to go back to exit and arbitrate?
Well, if the counsel for the plaintiffs will abide to the laws that the state made, and then we can move on back to.
So you're agreeing to go back to exit?
If I may refresh it with my counsel.
And you're agreeing to go back to exit or not?
If I may, please.
Yes or no? You agree to go back to exit, or are you just praying for this in this case?
We're praying this for this in this case.
Okay.
Yes. Thank you.
Thank you very much. So if I may now ask counsel for plaintiffs to have 5 minutes, and only 5 minutes, to rebut the arguments of the defendants. But I would ask that you rebut their arguments and not repeat your own. You can repeat your own in a minute, but it's more about rebutting its focus on what their argument was, and that it's wrong. You have 5 minutes.
honorable bench. Before I begin, may I request a minute to organize my sheets? Thank you. I may begin. Honorable Court, thank you for this opportunity. I would like to first bring to the Court's attention the statements made by my opposing counsel, my learned opposing counsels, that there are terms that are detrimental in this contract, yet the government of Gatronia, might I remind the court that what is at trial here is not the president, it is the government of Gatronia. That was the same government of Gatronia that signed this same contract, is today claiming that these terms are detrimental. They come here and claim detriment from the terms, yet they had the option to come to us straight via Article 9 to variate this agreement and negotiate peacefully. Yes, yet they have they have not attempted to do so in any sense, as the facts of the case clearly shows. There has been no communication, there has been no arbitration, and they have not regarded us with any opportunity to negotiate this matter. Further, my lady, I would like to bring your attention to the issue regarding the case of, the case cited, the American oil case, yes. This case was decided by an arbitrary tribunal in 1948, and as my knowledge of the law serves, that the doctrine of permanent sovereignty has begun to be developed by United Nations General Resolutions in the years following 1948. And if I may bring to this Court's attention decisions made after the decision of the American oil case, that specifically in the case of Saudi Arabia versus Aramco, decided in 1978, that the tribunal in that particular case stated that a state can grant rights from which it cannot withdraw. The sovereignty of a state, which they claim is extra-contractual, is, as a matter of fact, unbounded. They can, by their own sovereignty, bound themselves to not withdraw certain rights via contract. That was what they did when they granted us when they granted us the Lilo Pact. Here today, they come and rely on an outdated case to enforce a new doctrine. I would ask that the Court take notice of this. In regards to the matter of the Lugina Shubi Balonzi case, the councils have attempted to use this case in contrary to the facts that they have conceded to before this Court. The councils have conceded that there has been, as a matter of fact, detriment to the second plaintiff. There has been land that has been appropriated from the second plaintiff. They admit there has been jeopardy assessment as a result of the retaliation which the president, and I'm quoting retaliation from the council submission, retaliation of the president in regards to the matter of the Lilo Investment Pact. Further, if I may direct the Court to the matter regarding compensation of the land. My lord, it is clear, my lady, I apologize once again. My lady, it is clear from the facts that that my clients have been mining on this land for 30+ years. A mine is not bare land. A mine is not farmland. You cannot simply take a mine and return it to farmers and claim it is your returning farmland. That does not sit right with logic, as a matter of fact. Further, my lady, I would like to argue that as a bona fide user of the land, who has made various developments on this land, a mine is, if I may explain before this Court, that a mine is a complex structure. There are multiple developments, pits, and various other things that have been done on this land. To simply take this land and not compensate, claiming that you're restoring land to poor people, or to, sorry, poor is quoted from the submission of my opponent, it is not my word, specifically take from the rich to the poor. It is not something that this Court, it is not the law, there is no law to support such an action. Under the Land Acquisition Act, it is stated clearly that compensation should be done for the public purpose, and I apologize. Restoration of land, acquisition of land should be done for public purpose, and when it is done for public purpose, compensation should be given, even in that case. And the Court of Appeal has stated in the case of the Attorney General versus Lohaya Konai that even when land has been taken, and in that particular case, land had been taken many years ago, I apologize. May I complete my final statement here? Yes. In that particular case, land had been taken from the parties many years ago, and yet even after many years, compensation could still be given. If the president wished to make things right with his people, he could have compensated his people. As the facts clearly state, the person who did not compensate in paragraph 15, the government of Gatronia did not compensate its people. It is not my client who did not compensate these people. My client is a bona fide user of that land. They cannot be today a victim of a crime that they have never committed. I humbly submit.
Thank you. If I may invite counsel for the defendants to now do a Sarah button if they choose to. Would you like to do a Sarah button? Yes? So you'll be given 3 minutes plus the extra 1 minute of the case for the plaintiffs. So it's 4 minutes. And again, I'll invite you to respond to the specific points brought up by the plaintiff.
My Lordship and my Ladyship, I'm appreciated with this opportunity, and I'm hereby to express on the 3 issues that I have noted being debated by our fellow Lendi brothers. There is the opportunity to settle the dispute that the Gatronia government has not given any opportunity to the plaintiff just to settle the dispute. However, the dispute, there are some dispute and there are some acts that have been done by the president, and they have the opportunity to take the matter to the ICSID and make sure that they exhaust all the remedies found on the ICSID. Another one is on the compensation. He said that the land that has been taken, there was no need of taking the land back to the peasants, because on the mining activities, the land has been used maybe as a pit. However, in the fact, there is nowhere show that how that such kind of land that was taken back to the peasants have been used. We don't know if it was the pits or if it was the pits or something or any other is. Also, he is recognizing that he has admitted that the plaintiff is recognizing that the land was ill acquired from the peasants. So if he was recognizing, and he may be, and he also has an obligation to respect the human rights, because there is no that respect the human rights inherent. You may pray this on to was said in the commissioner, the commissioner of Musoma prison, whereby Marusanya said that raised the issue of rights, some human rights to the true son of restrained. It is pending. It is not used. What was the bid of the human right there? So if the plaintiff has recognized that the land was ill acquired and the land has taken back to the original owner, how can the plaintiff also come how can the plaintiff come also to request the court that the rent being taken back to the plaintiff? Thank you. I am to submit.
Thank you very much. coming out of Mooting. We're not. So normally we would walk out and we would stand and everything was very respectful. But we're not going to walk out, we're going to have a feedback session. So that brings us to a close on the finals of this Victory and Chinese Moot competition. And I just want to give a massive round of applause for our mooters. Phenomenal. I've been so impressed by what we've heard over all of the days, but with the teams who are in the finals just blew me away. In terms of your arguments, we are not real judges. This is not how it would be like in a real court, and we are purposely being naughty. I have been so naughty in this session. I don't know if you realise I was being naughty. So, for example, one thing I was trying to do quite hard was throw you off your argument, because in previous Moot sessions, when the judges had said something, people had so much deference for the judges that they just agreed, even though they were right in the first place. I tried to throw you off, and you stuck to your guns, so well done. The sexism point was not about throwing you off, about saying your lordship and your ladyships. Very important, I think, in any context, as somebody who's trying to persuade somebody to make a decision, that you connect with that decision maker. And obviously, putting the men before the women is never going to be good on this done. But also, what I quite enjoyed actually in the rebuttal, in the Sir rebuttal, someone had clearly heard what the judges had said earlier, and then built on that. I think one argument was I was trying to put in the argument on land and caveat emptor and bona fide purchases for value, and then on the rebuttal, the bona fide purchases for value came up. So I think there's some good listening that's been going on. I think it's in terms of feedback, as always, you're brilliant. You really are. You're really organised. You're really good stuff. I couldn't do that. When I was at university, there is no way I could do that at university. One thing about listening, the amount of listening is going to increase significantly. It's really important when you're rooting that you listen to your team. One thing we discussed in previous rounds, really important that you take a step back from this very large pack. I really like the fact this team, when they came in, take this as read. Then don't read it to us. Take a step back from your large pack and be able to know what the skeleton arguments are and be able to argue those. Otherwise, we'll just be reading along. And I like the rebuttal and the Sir rebuttal because in that circumstance, you had to really think on your feet. And throughout, I think you really did. You need to manage your judges. So I was asking political questions that were completely out of order. It's not the place of the judge or you as counsel to say what the government should or shouldn't have done with their laws from a political perspective or what's going to happen to investors in future. So you can actually ask your judges to say, ask whether or not this point is relevant to this, or you could move on. I think one really interesting point is you guys really listened to the previous rounds. So I saw, for example, one of the teams who I'd seen yesterday, instead of going for the argument on stability that wasn't going to win with me, they went for the argument much more on retrospectivity and looked for cases and found breaches of the contract specifically. I think it was really good the way you guys went back and you looked at the laws, you looked at the acts, you made sure your knowledge was perfect. But I'm so disappointed you didn't party last night in Dar es Salaam. What happened? You guys were just studying last night, right? So I hope all of the panelists were just studying last night. But I was completely blown away by this. I think you've shown us some amazing skill at mooting, a very good grasp of the law. And I'm really looking forward to seeing where this competition goes in future years and looking forward to the result. But everybody in this room is a winner. You guys were phenomenal. So well done. If I could invite my fellow judges to put some comments in.
Once again, well done. This was such a great competition and you should be so proud of this achievement that you have made.
A law student will never regret a mooting experience, and you'll come to realize that later once you enter the job market, just how much more sharpened your research skills are, how you're able to think on your feet. And I think those are really good skills and tools to have and practice as a lawyer. And so therefore, congratulations on what you have achieved so far. Job well done. Just a few pointers, I believe, and I hope that this will not be your only moot competition that you participate in, so for future references. First things, try to find out the major branches of law which your particular moot court case deals with. For example, in this particular case, there were aspects of public international law, there were aspects of corporate law, there were aspects of land law. So whenever you try to make a defense or you're trying to submit an argument, make sure that you know the legal context of the particular branch of law that that argument is relying on. For instance, you kept on being asked on what is the relationship between a parent company and a subsidiary company. That also had impacts on the direction of your argument. You brought up principles of the permanent sovereignty over natural resources. That's another branch of law. So try to have all these branches of law that are relevant to your case at your grasp. Another thing that I would advise is try as much as possible to preempt. What do I mean? For example, I purposely asked a question on the Luyuna Balonzi case because both sides of the, both parties brought up that case, but in a different position. Therefore, I was hoping, especially from the defendants, since you already heard that the plaintiffs had brought it up as its main argument to justify the locus standi, I was expecting that you would distinguish that case and show us why, despite that they had a holding that favored them, that you could distinguish this case and show us how it was not applicable in this particular circumstance. So you can try to preempt an argument next time. Or if a certain doctrine or principle is not absolute, don't ask us, or don't wait for us to ask you for the exceptions. Show us the exceptions. You may, for instance, you may say, we would like to invoke the doctrine of public trust, which states ABC. However, we do note that there are exceptions to this doctrine, which are as follows, but we aver that they cannot be applicable in this case because of ABC. So in that way, you would have already preempted the arguments from the other side. So that's just another thing to consider. And lastly, please strategically concede when you're backed in a corner. There were times when questions were being asked and you can tell that the counsel at the podium had no idea of the answer to that question, but they just kept on fighting and fighting, and sometimes it would get really sad. So you're lawyers, do not always just concede unnecessarily. You have to fight, but you have to pick your battles, because you must be able to weigh which point has major consequence if you concede and which point is worth fighting for. So I think that's a skill that you should also take into consideration. But otherwise, generally, great job. I commend you all for reaching the final rounds, and I hope that this will not be your last moot court competition. Personally, as a previous mooter myself, I found moot courts kind of addictive, and I think you will too. Once you have this experience, you'll want to go into another experience, and I encourage you to do that. But hongereni sana, I'm really proud of you, and I wish you all the best in your future legal careers.
Job well done once again to all of you, not just the finalists, but to other participants as well. Like my fellow judges have stated, doing moots changes your life, changes your thinking, changes your research skills, changes your exposure and the whole legal industry. I'm a previous mooter myself, and actually Hilda, Justice Hilda, is the one who was who was my coach back in university. She was a year ahead of me, and I did my first, I did my first international Moot with Hilda, and she was the team captain. So, and look where we are today. A couple of years later, the experience is still with us, and it has really taken us far. So I really encourage you all to make sure that this is not your last participation in a moot court. Participate in as much moot court competitions as you can. Having said so, I also have a few pointers that can help you when making arguments or in future moot court competitions. Oh, one other thing you did for the teams that I've met before, yes, they have actually made improvements. You've listened to what we advised you in the previous rounds, so it gives us an impression that you listen. So I can really say that the future is really bright. So thank you for listening, and yeah, I hope it comes useful to other competitions as well. One feedback is that please read the law fully. When you're researching and you find a provision that works in your favor, don't just say, aha, I've got it, this is the end. Make sure you go through other provisions as well, because one aspect of your facts may not be confined in a single provision. We asked during the session, we asked more than once that, can you please give us an exception to this legal requirement? Are there any avenues? We were expecting you to tell us, yeah, there are other remedies that we could have explored, but we could not explore these other remedies because of 1, 2, 3, 4, 5. There are actually other remedies, so we were hoping that you would have responded to that. Another thing is that don't bring in new facts. Just because something is not stated, it doesn't mean it is the opposite. As a lawyer, do not assume facts. You state facts, you prove facts, you submit facts, and you persuade with the law applicable. So don't bring in new facts. As the lead judge said, you need to know your judges. So research your forum properly. When you go to ICSID, when you go to the High Court Commercial Division, when you go to the High Court Land Division, things are different. Procedural rules are different, persuasion is different, jurisdiction is different, and the applicable law is in one way or another different. So always know your forum. If you know your forum properly, you'll be able to use the right legal authorities to persuade the forum you're at. Have a grasp. I've stated this since yesterday. Have a strong grasp of your facts and the law. We were glad that during this final session, you requested the court to take the memorials as read. So you had less reliance on your memorials. You keep improving, which is good, on reproducing what you have written. So that's very good. But have a strong grasp of your facts at your fingertips. If you have facts at your fingertips, if you have the law at your fingertips, it will help you build confidence. The role of judges to ask you a lot of questions. Yes, sometimes it's to shake you and to see how strong you are, how well do you know your case. But it is also an opportunity for us to get to know you, to get to understand the plight of your case. So take it as a conversation. So if you know your facts and the law at your and the law applicable at your fingertips, you won't be shaken. Trust me, no matter what questions come thrown at you, you won't shake. So have a strong grasp of your facts and the law. And also, please take this positively. When you submit, lawyers do not and I mean in terms of when you're submitting, when you're presenting something, we do not think, we do not give an example. We draw inspiration, we persuade with, we submit, we avere, we pray. We do not think. When you're asked a question, please avoid, even on your daily assignments and whatnot. When you're asked something, avoid say, I think. If you're thinking, that means it is not in existence. If it is not in existence, why are you bringing it up? How is it persuading? If you think that they have violated, that means they have not violated. You are thinking that they have violated. A court is persuaded by evidence, by facts and the law. So if you are thinking, we will also think. So please avoid use the word of thinking. Last comment, read cases. Have a case. I like the fact that someone distinguished a certain case that was cited came after a certain international principle was established, so that's good. Know when was the case decided, know the facts of the case. The reason why we insisted, or we kept repeating, please tell us facts of the case, is we want to know and to make you understand that counsel, this case, the facts of this case are distinguishable from the present case that you're trying to make. So read your cases fully, read full judgments. We've been students before, so we know that sometimes you just read the summary and that's just it. No. In real life, my friend, read the full judgment, understand, and see if the circumstances of the case you're persuading us with is relevant to the case at hand. Those are the comments I have. I hope you find it. I wish you all the best in your future endeavors. Please don't stop mooting. Moot. And thank you, Victoria, for having us. We really appreciate. One last before joining Moot and in the coaching, we used to seek guidance from lawyers that had gone before us. And one of the parts that Victoria told us was we call them veteran mooters. So we use for mentorship, advice, and yeah. So we really encouraging young students. Please keep it up, and thank you all for having us. Thank you.
So I think also I would just to add one more point, not to the mooters, but generally to the organisers, it would be really good in terms of, there were a few mistakes on the law, I think throughout all of the moots. As judges, we can't tell you when you're wrong on the law. Apart from in this final, we were able to say at some points that check this and check this, because otherwise it would be unfair for later rounds. But it would be very useful to talk about, I think after the cocktail or later occasions, the places where people went wrong on the law and need to check those particular laws. But generally, you guys had a brilliant grasp of the law. So my understanding is then that the final is closed for now, and that's the feedback that we have. But there is to be further discussion on the mooting experience and an invitation to the partners who have organised this, including Victory Attorneys. We've got the TLS, TIAC, Twaweza, East Africa, and others to come up and present. I don't know, Benedict, and firstly, veteran does not mean old. Please note for Benedict. You're still in your prime. Do you want to do further on the moot sharing experience?
Perhaps you close the court so when people are feeling relaxed and then we talk it inside.
Oh, we're doing this one. Okay, perfect. Okay, good news. We're closing court. The judges are standing. You don't have to stand. That's fine. But yes, thank you all for coming. I think we're going to move the full agenda to the Serena, where we'll be having a cocktail. So I look forward to seeing you at the Serena. Thank you very much, and a round of applause. Yes, we should be marking now.
All. Now, the judges are going to the announcement of the winner will be Serena, and also the award giving will be Serena. And we will start at 5:30 with Serena. So for students, you have for us, invite a guest and let's.
I'm sure, Martin, you were really impressed by, well, I don't want to put words in your mouth.
I can't wait, obviously, so I missed I'm very impressed. It's something I have to as a student. It's something I became a corporate theatre. It's very impressive, I must admit. The confidence which both teams spoke was fantastic, and the authority they had on their points was also very impressive. So thank you for allowing me to join you today and to take part in the Moot. Thank you.
Thank you, and I hope to meet you as Martin, I hope to see you as
Sure, yes, of course,
sure,
yes.
Asante, sir.